Hello, everyone. Thank you for attending. I'm Bob Stang, a partner in Husch Blackwell's international trade practice. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit the questions via the question box. We'll try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, the question will be answered later by email. A PDF of the presentation is going to be available in the program materials folder. This program has been approved for legal education hours. For live attendees, please report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs and really appreciate the feedback. So that's all for the housekeeping items, and let's get started with our program today on the Uyghur Forced Labor Prevention Act. The speakers joining us are William Billy Jensen and Jasmine Martel. Billy is the branch manager with No Adam Logistics. No Adam Logistics is a full-service logistics company providing a variety of freight management services, international supply chain management, and global trade logistics services. Billy's in the Chicago and Buffalo offices. He's a licensed customs broker and a certified customs specialist, and he is also responsible for No Adam's centralized brokerage program, which facilitates customs clearance into the United States and Canada, as well as No Adam's global trade management team providing advisory services, and we're really happy to have him with us here today. Jasmine is an associate attorney at Husch Blackwell in our Houston office. Jasmine started her career working in compliance for oil and gas businesses and is now part of our international trade team, where she focuses on customs and trade remedies. And so with that, let's turn it over to Jasmine to kick it off and get us going. Thank you.
All right, well, good afternoon, everyone. Bob, thank you for that introduction, and thank you all for joining us today to talk about what has been a leading topic in the customs world right now, which is the Uyghur Forced Labor Prevention Act. And so I'm just going to kick us off basically giving an overview of this new act, what it looks like, what the implementation guidance is, just so we're all on the same page. And then later on in the presentation, we'll get into more of your practical implementation strategy and things of that nature. So our forced labor laws stem from the Tariff Act of 1930, which essentially prohibits imports made with forced labor. And then in 2020, we also saw the Uyghur Human Rights Policy Act, which imposed sanctions for human rights abuses in the Uyghur Xinjiang region. And then as of last year, what we all know is that the Uyghur Forced Labor Prevention Act was passed in December, and that expands upon the enforcement of sanctions against forced labor. And so this particular act addresses goods that are produced in the Xinjiang region with forced labor, and it strengthens the prohibition of importing goods that were made whole or in port with forced labor. In terms of enforcement, we're seeing a change in the landscape and how forced labor is being enforced now that the Uyghur Forced Labor Prevention Act has been passed. So initially you had your WROs, your withhold release orders, and now we're going into the UFLPA enforcement, and there are some significant differences. One being the amount of time that you have to respond to your detention decreased significantly from your 3 months, your 90-day time period, to now just your 30 days under the UFLPA. Addition to that, you have a different level of evidentiary standard that you have to meet, that being your clear and convincing evidence standard, which we'll discuss later on in the presentation. So by now, I'm sure we all know that the Uyghur Forced Labor Prevention Act establishes this rebuttable presumption. And that presumption is essentially that if you are importing goods that are made in whole or in part from the Xinjiang region, then they are presumed to be made with forced labor and are therefore prohibited from being imported into the United States. So that's going to include your inputs, that's going to include your raw materials. And one important thing as well is that there is no de minimis. And so any trace of an input that is, sourced from, made in the Xinjiang region, your goods can be subject to this UFLPA standard. And so this rebuttable presumption went into effect last month on June 21. And essentially, those shipments that are coming from a company in the Xinjiang region or coming from an entity, produced from an entity on the UFLPA Entity List would bring them within the scope of this Forced Labor Prevention Act. So just from a high level perspective, Customs has said that they are reviewing these shipments all on a case by case basis. And how this works essentially is that if you have an UFLPA shipment that Customs has identified and they've taken enforcement action, then you receive a notice of your detention or exclusion or your seizure. And from there, the importer essentially has to determine, okay, are my goods in scope merchandise or are they out of scope merchandise? With your out of scope merchandise, what you're saying is, wait a minute, Customs, you've detained my goods, you stopped my goods, but there is in fact no connection to any entity on the entity list. There's no connection to the Xinjiang region. None of my inputs are from there. And so let me provide you with substantiating documentation to show that there truly is no connection. And then from there, if Customs actually agrees there is no connection with this particular merchandise, then no exception request will be required and the goods can be released. On the other hand, the path that is much more difficult to overcome is whenever you have your in-scope merchandise. So with in-scope merchandise, you would have to request an exception. And in that scenario is where you would be providing that clear and convincing evidence to Customs. And from there, the commissioner can then grant an exception if the importer actually meets that burden and overcomes that burden. In terms of enforcement, Customs has their 5 days essentially to determine if the goods are going to be detained or not. If they have not determined that by the 5th day, then your goods are considered detained. And from there, the importer has that 30-day period to respond to Customs. You can ask for an extension of time, but best practice would be to just try to respond within those 30 days. And then Customs will make their final determination of admissibility within the 30-day period. And now I'm going to pass it on to Billy, and he's going to talk a little bit more about how you know in the first place if your cargo has been detained.
Thank you, Jasmine. So one of the most common questions we get as a broker on the practical side is from importers is how will I know when my cargo is held and that I need to take actions? And the answer is it all starts with the broker filing the entry. When the broker files an entry and Customs wishes to take action on it, they will input what's called a flag for an intensive exam, where they will notify the broker that they would like to see the entry documents and that it must be made available at an exam site. This timeline is important because under a normal course of business, an entry will be submitted prior to freight arrival. The intensive exam flag will go in, and there'll be several days before that freight is made available, the vessel arrives, and the freight is ultimately made available at the examination site. Generally, in cases we've seen, detentions have not come as a surprise. So when we see high risk freight or high risk vendors being flagged for intensive exam, this can buy us a couple days before that 30-day clock starts to start working on a response and pulling documentation. So once freight is physically, made available at the exam site, that starts the 5-day clock for customs to issue the detention notice. And generally that'll happen quickly based on how fast customs can view the freight. There's not much sort of testing they can do on the freight to make that determination. So it's generally made quickly based on the data they already have. And as Jasmine noted, once that detention notice is issued, importers will have 30 days to provide a response if they expect to contend. The alternative situation and an unfortunate reality is that customs may issue a redelivery notice where freight was cleared, and within 30 days they require it to be returned back to the port, which it was cleared at. This can present a lot of challenges with freight being installed or potentially even already hitting shelves or being offered for sale on the internet. So we've had several clients that have struggled with this, and there are some pretty hefty fines that customs can hit you with if you fail to redeliver timely. The silver lining here is similar to what I discussed with the flag for intensive exam, is when you have a redelivery notice, customs will give you a reason why, and you can begin formulating a response to the customs concerns prior to that freight being delivered and that 30-day detention notice clock to start. So important to use the time you have wisely and be proactive when these proceedings occur. So I will kick it back over to Jasmine.
Thanks, Billy. So in terms of enforcement, once you have a detention, we know that it could turn into customs excluding the goods. It could also turn into a seizure or a forfeiture. If customs decides that they're going to exclude the goods, then the importer can file a protest against the exclusion. And similarly, if customs decides that they are going to seize the goods or forfeit the goods, then the importer can file a petition to request a cancellation of the seizure and mitigate any penalties. In both instances, the importer also has the option to request permission to simply re-export the goods. So I want to shift gears a little bit now to the exceptions to the rebuttable presumption, because we know that customs has said that these exceptions are far and few in between. It's a really tough burden to overcome, but the importer may request an exception after their goods have been detained, excluded, seized, so on and so forth. And in that case, once the importer receives their notice, then that notice will have particular instructions for the importer to follow. So it'll be pretty important to make sure that you know what part of the process you're in so that you're requesting an exclusion under the correct procedure. And then finally, if the exclusion is granted, the importer has met their burden of proof, then Customs is going to make a public report to Congress within 30 days of granting that exception. So how does the importer meet the exception burden? Exceptions may be granted if the importer, number one, fully complies with the customs guidance, they comply with the regulations, and they also completely and substantively respond to all inquiries of information. Finally, the exception will be granted, can be granted, if the importer established by clear and convincing evidence that there has been no forced labor with the importation of those goods. And so, as you may know, Customs has released their operational guidance, and the FLETA, the Forced Labor Enforcement Task Force, also provided their list of acceptable documentation and practices that will help to overcome this burden. And I'll kick it over to you, Bob, and Bob is going to talk about how importers can be more proactive in addressing this new landscape that we're in.
Thank you, Jasmine. That's great. So for a lot of folks, you haven't received a detention notice, but you're aware of what's out there and you're aware of the risks and the penalties and all of that, and you want to be proactive. So the question is, where do you start and how do you start? Well, in our opinion, the place to start is with full supply chain tracing. And full supply chain tracing means that you have to start from the raw material suppliers, okay, and the subcontractors, and you have to go all the way up to the finished goods. Now, the documents that we've listed on these slides, these are documents that Customs has suggested, okay? And we're going to try and break them down into different groups for you. And the first is that we just want to emphasize that the documents that you're going to be, that you would be providing, and this would be for internal purposes because it's being proactive, but that they are documents that if you did receive a detention notice, that you would want to provide or might want to provide to Customs. So keep that in mind, and keep that in mind as with respect to what you're requesting and how you would organize it and all of that. So a detailed description. Customs, it's interesting, also wants to know if the importer is related to any of the vendors overseas. If you have any questions, are you related? We have the provision in the Customs regulations. It's more, by the way, than just a corporate relationship. Families, blood relationships, things like that also count. Suppliers associated with each step in the production process, and Customs also wants, if you were going to provide it to them, they want the names and the contact information for the suppliers. So we think that if you are being proactive, that you should attempt to be getting that information as well. Affidavits. And now that's really interesting because there's certain information that a supplier ordinarily, they're not going to have, it's not going to appear on a purchase order, an invoice, or a proof of payment or something like that. And so for an affidavit, we think that if you're going to get an affidavit from one of the foreign vendors, that first of all, you have to be careful that the affidavit should identify the company, but we have found it particularly helpful also that the affidavit should identify the location of the company. In many instances, the companies are thousands of miles from the Uyghur region, from the Xinjiang Uyghur Autonomous Region, and we think that that's something that you can put right into the affidavit. In addition to that, we think that the affidavit should state things affirmatively. Here's the goods that we produce. Here's the quantities, for example. Here's the nature of the goods. Customs has been concerned in forced labor issues about commingling. So, for example, if you import wearing apparel and you say, well, our cotton came from Australia, Customs says, well, how do we know that you didn't commingle that cotton from Australia with cotton from from the Uyghur region? That is something that you can put right into the affidavit, a statement of no commingling. And then, of course, the name, the title, and the date. So these affidavits, once again, you're being proactive, but this is the kind of information that you should start requesting. And we would emphasize that if you can't get this information from your overseas vendor, then that's starting to identify for you where some gaps might be, and it's starting to identify for you where some you might have some issues. In addition, we can move the slide forward. There we go. Customs is asking for transactional documents. Transactional documents are basically the paper trail. The purchase orders, invoices, payment records, things like that. Well, one question that comes up from time to time, by the way, is how far back should you go in the paper trail? And we think that how far back you should go, particularly if you're being proactive, to some extent it depends on, really what's possible. And I guess, Jasmine, let me ask you this question. So what if an importer of record can't map the entire supply chain? What kind of advice would you give them?
Yeah, so we would definitely suggest that in these cases, you're taking a risk-based approach and doing a risk-based assessment. I think what you never want to do is say, well, our supply chain is too big, it's too locked, and we got too many moving pieces, and so we just didn't do any mapping. Instead, what you want to do is say, okay, do I have any of these quote unquote targeted products that customs has already said are at high risk for forced labor? Or am I importing from the Xinjiang region? And those are the places where you would start and work your way from there, from a high level, high risk perspective. And then also impress upon your suppliers to provide you information as well. So it really is putting the pieces of the puzzle together and using all the information from your business partners in order to get what you can and show that you are doing your due diligence.
I think that's good advice. Thank you. Now, Customs is also asking for full mining, production, and manufacturing records. And what we would just emphasize here is that they're telling you to trace the raw materials. So once again, you really have to go back beyond the vendor of the finished goods. Now, it's interesting that this comes from the Customs website, they have their operational guidance document, and at least with respect to certain goods, there are certain goods that are of more concern, tomatoes, cotton, polysilicon, for example. And Customs is emphasizing that importers, at least with polysilicon, should be aware that imports of goods from factories that source polysilicon, and we have it here, both from within the Xinjiang region and outside of the Xinjiang region, being risk subject to detention. So that's simply emphasizing to folks that you're purchasing finished goods from China and your vendor of the finished goods is outside of the Xinjiang region, outside of the XUAR, the Uyghur region, and that is not necessarily a guarantee that your goods are not going to be detained for forced labor purposes. So, in addition to full supply chain tracing to the extent possible, what are some other proactive measures that people can take that we have found are particularly helpful? Well, one thing is just having written guidance to your vendors as to what's not permissible. And we think, once again, that when you create that kind of a document, you should be thinking, well, if you had a detention, is this a document that you would be able to provide to U.S. Customs? But we also think, and we've seen this for a number of importers that we work with, that they're writing the requirements into the purchase orders and into the larger supply chain agreements. And also when they write that information into those kinds of contracts and documents, they're also setting in there who's going to be responsible for the costs if something has here. Is somebody going to, and is the factory overseas going to indemnify the importer? What happens if you have to re-export the goods, and who's going to be responsible for all of that? So we think that it's just a good proactive measure to start putting that into those kind of documents. And of course, that puts these issues on people's radar. Affidavits and certifications from vendors. Once again, an affidavit is not an entry document. It's not something that you have to have. But we think that as a proactive measure, if you start asking your vendors for certain affidavits and certifications, once again, you're putting this issue on their radar. What kind of information would you have on there? Information, for example, that they understand U.S. forced labor standards and that no forced labor has been involved at any stage of the production. There's also record-keeping requirements. If Customs detains your goods and you're going to claim that these goods had no connection to the Uyghur region, that they're out of scope, then Customs is going to start asking you for production records to confirm that. So you want to you would want to get your vendors at least on record that they understand the need to keep those records, that those records will be available to you upon request, things like that. Social compliance audits, and that's a really interesting proactive measure. And there are some very, very good companies in the United States and outside of the United States that perform full service social compliance audits. Now, that can be a double-edged sword. First of all, if the vendor overseas undergoes a social compliance audit, the question is, did they pass the audit? And we have absolutely seen situations where vendors say, well, but I was audited by, and they'll list some of the larger, more reputable companies. And when we look at the audit report, it turns out that they did not pass all of the audit. So you have to be careful about that. The second thing we would point out is we have seen situations where companies performing social compliance audits the scope of their audit might be far in excess of what might need to be required for a forced labor audit. So if you are going to go that route, that's a great idea. We encourage it, but you should look very carefully at the audit plan and at the issues that the auditors are going to carry out to make sure that they're meeting your needs and that they're not going way beyond what might need to be required. Keep in mind, if you get a social compliance audit, that's a document you might want to provide to customs in the future. So be careful about what they get and about how they document it. We have also seen situations with companies performing social compliance audits where they did not perform the audit to customs standards. So for example, we saw one situation where a company provided a number of pictures and images of the factory, and customs rejected all of them because they said, well, there's nothing here that's geotagged, nothing has a time or date on it. So you really want to make sure that who's ever doing this, that they understand where the results of their audit might end up. And the last thing, and this is really important, and particularly as we're coming out of COVID, visit the factories. You know, there's really nothing, sometimes there's no stronger evidence than you being able to say, you know, I was at the factory 30 days ago, 3 months ago, or our employees were there, and we do regular visits to the factory, and we have records of the factory, and you have your own pictures of the factory to really show what kind of due diligence that you've done to make sure that you understand that you know who you're dealing with and that you've personally eyeballed these factories to ensure that they're meeting U.S. standards. So another proactive measure, and this is a difference actually with the UFLPA statute, Customs has been clear that they will issue binding rulings. And the binding rulings would essentially be that you would provide full supply chain details to Customs, and then they would issue their ruling. Presumably that ruling will be public and it'll be on the cross module on the Customs website, but it would reach a conclusion that your supply chain, it meets UFLPA forced labor standards. Customs has been clear that if you do get a binding ruling, that ruling, it will only apply to goods before the goods have arrived at the port. So if your goods arrive at the port and you get a detention notice and then you apply for a ruling, that's no good. Now, one question that comes up from time to time is, well, okay, you know, we have a particular supply chain involving vendors and subcontractors and logistics freight providers, customs brokers, carriers, all of that. And sometimes you get changes in the supply chain naturally. So what kind of a supply chain would invalidate a ruling? Or alternatively, what kind of supply chain change could be made and enable you to continue to rely on the ruling? Well, if you have a change in vendors, so you're buying from vendor A in your ruling, and now you're saying, oh, it's a vendor B, okay, that's going to probably invalidate the ruling, because then obviously, how does customs really know where the goods are coming from, any kind of production methods, things like that. Alternatively, if we're talking about a change in logistics suppliers, we would say it depends. If you're merely using one ocean freight carrier as opposed to a different one, I think that's entirely normal and standard, and we wouldn't see that invalidating a binding ruling. The same thing for a customs broker, assuming that it's a reputable customs broker, things like that. Alternatively, if you had a situation where, for example, the goods were going to a consolidation center identified in your ruling, but you changed consolidation centers, that would be something where we could see customs saying, well, that's a serious enough change in the supply chain that they would say, okay, you can't rely on that supply chain anymore. Now, for folks that have obtained rulings from customs, you know that the agency typically tries to issue the rulings within 30 days. A lot of times customs will send a letter back to you and say they need additional information, in which case the ruling gets kicked out and you have to resubmit it. And to some extent, UFLPA, with respect to binding rulings and how customs is going to handle them, we think that has yet to be seen. I would imagine if customs just gets an overwhelming amount of rulings, you're going to see a lot of rulings getting kicked back. I would also expect that it'll be interesting. Well, we also think it'll be interesting to see exactly how much information, how much supply chain mapping is customs going to request before they actually issue a ruling. Once again, rulings are public on the cross module on the customs website. At least as of yesterday, there were no UFLPA forced labor rulings on that website. Actually, very few forced labor rulings, even specific to 1307. However, there was one that caught our attention, and we've got the ruling number up here, H317249, if only because it's fairly recent, from last year, and the standards under which it was wearing apparel and the standards under which they were evaluated were somewhat similar, whether the apparel was produced wholly in part, in this instance, by North Korean nationals. It was interesting that the importer in this ruling submitted a RAP report. RAP is one of the most well-known agencies for evaluating factories and production. It's widely accepted. Nevertheless, customs dismissed the RAP report and instead relied on an investigation by a British newspaper and stated that they had not established by clear and convincing evidence that the detained garments were not produced with forced labor. Recognizing what you might have to do if you were ever challenging in scope of UFLPA goods, I think that this ruling basically puts everybody on notice that even if you have an audit report by a widely accepted and accredited forced labor entity, that's not going to be good enough. And look at what they relied on instead, an investigation by a foreign newspaper. So with that, the question then becomes, well, those are all good for proactive measures of the full supply chain tracing and getting a binding ruling and all that. But what advice would we have for folks if you actually receive a detention notice? And for this, I'm going to kick it over to Jasmine to give some thoughts on, what are the first steps an importer should do if they actually get a forced labor and UFLPA detention notice?
Yeah, so first and foremost, the importer is going to need to look at, deciding if they're going to re-export the goods or not. And if they say, okay, well, I'm not going to re-export the goods, then it goes into, well, are my goods in scope or are they out of scope? And if they're out of scope, and I'm confident they're out of scope, and I want to go head to head with customs and show them that they're out of scope, then that would be one option. Or if they're in scope, then you need to look at the likelihood that you'd actually be able to prove and overcome that burden of clear and convincing evidence, that the goods were not made with forced labor.
That's great. Billy, what would be your advice to folks if they did choose to export the goods?
Yeah, alternatively, if it makes more sense to export the goods based on those factors, the importer would need to work with either their freight forwarder, the carrier, or the customs broker to make arrangements for the freight to be moved outside of the country. Customs has not dictated where they move outside of the country, if it's to a different destination or if it's back to the actual origin. But what happens is arrangements are made, a booking is made generally with an ocean carrier, and customs expects to see that booking and what's called an immediate exportation bond to be issued. So that's either issued by the exporting carrier or the broker. That is presented to customs, which is used to cancel the entry, which was detained, and the goods may be exported. The important call out here is customs has been a little bit inconsistent in how they've canceled the entries and the timeline they've been doing that. So it's very important that the broker follows through and ensures that that entry is canceled. We've seen customs input a release on entries instead of canceling them, which triggers a potential duty payment and headaches down the road. So important that that copy of that export bond is received and presented to customs and followed through. Thank you.
Great. So if you choose to contest the detention notice and you believe that the goods are out of scope, and as Jasmine mentioned, that means there's no connection to the Uyghur region, there is no connection to any entity on the UFLPA Entity List, and when we say no connection to the Uyghur region, we're talking not only about the finished goods, but raw materials and inputs as well. If you choose to contest the detention notice, then once again, full supply chain tracing, which actually gets back to the proactive measures that we talked about, the list of documents, those are the kinds of documents that you're going to have to provide to customs. It's been interesting that we've seen instances where people get the necessary documentation, but when they provide it to customs, they don't always provide it in an organized way, and sometimes they don't provide translations of the documents, and they don't show how one document links to another. So if you are going to provide documents to customs to contest a detention notice, you're going to say that you're out of scope, then it's not simply getting the documents, it's making sure that a customs officer can read the documents or read a translation of the documents. It's making sure that the customs officer understands how the different entities relate to each other. If you're in the apparel industry, you have one company providing raw cotton to another company perhaps that's manufacturing yarns, to another company manufacturing fabric, to another company dyeing and finishing the fabric, and then that being provided to the company cutting and sewing the garment. So you really want to make sure that your documents track through in a very orderly and clear way, so that somebody at customs can understand exactly what's going on. Now, what happens if your detention turns into an exclusion? Well, as Jasmine mentioned, you have the right to file a protest against the exclusion. That's in the statute, 19 U.S.C. 1514. And by law, protests have to be filed within 180 days of the date of the exclusion. But in this instance, you definitely do not want to wait. If you're going to file a protest, you really should do it as soon as possible. And if you're going to file a protest, we think it should be filed as a protest into what's called an application for further review, which means you check a few boxes when you're filing the protest. And then if the customs officer who's reviewing the protest doesn't agree with it, they have to forward it on to a higher level up in customs. When you file the protest, you should have all of the supporting documents available. If you don't have those documents, don't wait an unnecessarily long period of time to file the protest. Get the protest filed. If you need to submit documents a little later in support of the protest, if you need to call customs and say, look, I'm going to have these documents in a few days and you're going to submit them in support of the protest, then do it that way. Better to do it that way rather than not file the protest. The protest, by the way, is going to be decided by the applicable C, the Center of Excellence and Expertise, for a decision. So for folks who are wondering, well, who's going to make the decision on the protest, it's going to be through your C. And the person, as we know, the Cs are virtual. So you could enter the goods through Long Beach and it could be somebody in Newark that makes the decision on the protest if that person is in the C. If the protest was filed as a result of a final determination or deemed determination of exclusion, if it's not decided before the 30th day after which it was filed, then you can treat the protest as having been denied. You don't have to. But if you do, then that would let you go to court. If you're going to go to court on this, you really should have a denied protest to get into court. Which takes us to the next part of this, which is, yes, you can go to court on this. If you do go to court, then you're going to have to establish, customs would have to establish by a preponderance of evidence that the admissibility decision they reached, which is basically their admissibility decision is that they're excluding your goods, was not reached for good. Was not reached for good cause. A preponderance is basically the 50-yard line. So customs basically has to get the ball across the 50-yard line if you're in court to support that whatever they did was appropriate. Otherwise, if they can't reach the 50-yard line, and that happens from time to time, and also particularly with forced labor detentions, customs has not been, we would say, particularly transparent in identifying exactly what evidence or documents or whatever they're relying on. Then if they can't reach the 50-yard line, then the court, it says, shall grant the appropriate relief, including an order to cancel the detention. We would also point out when they say grant the appropriate relief, that can be something other than canceling the detention. They could basically remand it back to customs, give a more thorough determination. Finally, if the detention turns into an exclusion, once again, in lieu of seizure or forfeiture, customs can deny entry and permit the merchandise to be exported. And we have the citation there to the customs regulations, and we're just emphasizing that the procedure, the UFLPA procedure, as opposed to the procedure where goods were detained under a withhold release order, WRO, is under section 151.16 of the customs regulations. Of course, if customs is going to permit you to export the goods, then importers should be sure that they understand that the importer is going to be responsible for paying all the expenses, which really gets back to another point we made, which is that you probably want to have some sort of agreement with your vendors that if goods are exported, who's going to be responsible for the costs of exportation. So now, what happens if it's not simply that the goods are excluded? What happens if the goods are seized? That also is a possibility under the UFLPA. And the statute is 1595A. And 1595A, we would also emphasize that it permits for penalties. And we would also mention that 1595A, the statute under which they could seize and penalize companies, Customs has been clear that they are not intending to use this statutory provision widely for forced labor seizures, but it's part of their arsenal. And we would also point out that the statutory provision is not limited to the importer or to any party. It says every person is potentially covered. If you were faced with a penalty under 1595A, then penalties are often mitigated. If it turns into a seizure, you could ask them to cancel the seizure upon permission to re-export the goods. So if the goods are seized, that probably is a situation where you would want to be contacting counsel, at least for privilege issues, if there's any serious issues or concerning issues along those lines. But the seizure can be canceled if Customs gives you permission to re-export the goods. And if there's penalties associated with it, penalties can be mitigated. There's mitigated guidelines, all kinds of things. Now, one issue that comes up and that has come up is companies, particularly for companies that are in CTPAT, the Customs Trade Partnership Against Terrorism, which is the premier CBP trusted trader program. And the highest status for CTPAT trusted traders, partners with Customs in supply chain security, is a validated Tier 3 status. And on the CTPAT UFLPA page, on the page, there is a CTPAT UFLPA known importer letter, okay, and we're emphasizing that that letter says, and this would be a letter issued to the CTPAT partner, subsequent entries of such merchandise may result in, among other things, suspension, removal from the CTPAT program, seizure, forfeiture, or penalties. So the fact that you're in CTPAT, which is difficult in some respects to, particularly as the program is today, I'm sure a number of companies know, to make sure that you're really meeting CTPAT standards throughout your supply chain. That might get you some mitigation in terms of penalties and whatnot, but it is not going to remove you from a company subject to UFLPA detentions or seizures. So this brings us to our last slide. And the last slide is, well, if you get a detention notice and you know that the vendor or somebody is in scope, meaning that they have some connection to the Uyghur region or they have some connection to an entity on the Uyghur entity list. And Jasmine, I thought, gave a really good summary of the standards that Customs is going to hold you to, the clear and convincing evidence standard, and the summary of the kind of information that you would have to present to Customs. What we would say is, and Customs has been very clear about this, that if you choose to contest goods that are in scope and you want an exception to the rebuttable presumption, good luck. It's going to be very hard to get that kind of an exception. Customs is going to really enforce the clear and convincing evidence standard very strictly. We would go back to the ruling that we cited on the North Korean goods just as an example of how strict they can be. We would also point out, if Customs were to give an exception to the rebuttable presumption, then they have to go to Congress and they have to make a public report on exactly what they did. Nobody from Customs, I can imagine, would want to go to Customs and say, oh, we let in, these goods had some connection to the Uyghur region, but we let them into the United States. It's just not something that somebody wants to do. So our advice to folks is that if you get a detention notice and your goods are in scope, really, you should try to re-export the goods, because that's just, in the long run, that's going to be the easiest and quickest way for you. So with that, we have time for some Q&A here. And what I would like to do is just read a few of the questions and kick it over to Billy or Jasmine. So Billy, let me give you the first question here. And the first question is, if we receive a detention notice and part of our goods would be covered and part would not, is there any provision or any ability to get release of the goods that are not covered? Billy, what would be your thought there?
Yeah, absolutely. Thanks, Bob. So on the detention notice, it's very important the detention notice lists exactly which portion of the entry is subject to the detention. Normally, they'll do this by identifying an entry line number, when, incorporating an HTS and a manufacturer identification code. And the answer to it is possible to obtain release for the goods not in scope. What must happen is the goods must be located at a customs bonded facility, and a manipulation request is filed with customs where we ask for approval to segregate the goods, identify which sort of carton numbers or which products are subject to that line of the entry, and a additional entry is filed for the goods that are not subject. And I think this is really important to really take a close look at that detention notice if and when you receive it, to identify if it makes sense. Because we have seen times where just on face value, based on the products and manufacturing, it doesn't make sense that all goods are in scope. And we have sort of pushed back to customs to clarify that, and they have revised their detention notice to specifically identify which lines are subject.
Great. Jasmine, let me ask you a question. What should an importer do if we plan to have several shipments being imported with the same supply chain makeup, or we're unsure if our UFLPA would apply to our transaction?
Yeah, so I think, Bob, that's definitely one of the scenarios where the importer can go ahead and try to request a binding ruling. Also keeping in mind, however, like we mentioned previously, that you are not getting that binding ruling and then applying it to supply chains that differ from that supply chain makeup that you mentioned in your binding ruling. So you want to be really careful with that ruling is specific to that particular supply chain, and not whenever you have certain changes from suppliers or routes and things of that nature.
Great. Billy, let me ask you this question. If an entry is not flagged as pending an intensive exam, can you presume that there's no issues or concerns? What's your experience there?
I wish that was the case, but we have seen several instances within the last, probably 60 days where entries were flagged for exam, almost on the final hour of that 30-hour deadline, and customs had requested those to be returned into customs custody.
Okay. Here's another question. How far away from the region is far enough that they would consider if not at risk? So that's a really interesting question. There's no bright line there. What we've done is that when we've created affidavits and submitted affidavits to customs, the Uyghur region is in the northwest part of China and is oftentimes thousands of miles away. And if it's thousands of miles away, you can actually go to Google Maps and get the approximate number of miles. And we've actually, put that in there. This vendor is 2,100 miles away from the Uyghur region. I would say it's the optics. If you have somebody who's 50 miles away, that's probably not going to do it. And obviously, if you have somebody who is thousands of miles away, then that's something that you definitely want to put in there. So now we have a question. How can industry modify their written guidance for UFLPA purposes and not violate the China blocking statutes? For example, when updating the sales terms and conditions or supply chain agreements? That's a really good question. And what we have seen is that sometimes there's confusion over exactly what's permitted and what is not permitted in China. And we would simply say, go to counsel if you have counsel in China. But we have absolutely seen situations where people have been able to write guidance or to write language into their agreements, into their supply chain agreements and into terms and conditions and into those sorts of things. So we now have another question. How do you get Chinese vendors to sign purchase orders with these requirements? There is no right way and there is no wrong way to do that. You really have to have a relationship with folks over there, and you have to prevail on those relationships. And I guess this really gets back to you really have to know who you're dealing with. And if you're going over there and they know you and you've been to the factory several times and you sit down, our experience is that you should be able to work out language that makes everybody comfortable. And if you can't get folks comfortable, then you really have to start asking yourself why. Is that indicating that there's some weakness in the supply chain that needs to be addressed one way or another? So another question here. When trying to prove out of scope, how do we get ahead of any customs assumption of commingling? That's a wonderful question. And an assumption of commingling, that really and oftentimes means that customs is asking you to prove a negative. You know, you're saying there's no commingling. How do you prove that? Well, there's a couple of things you can do. One is you can put that into affidavits. Okay, that's a little self-serving, and customs has mentioned that a few times. Another thing that you can do is you can start matching up quantities. So, for example, if it's in the apparel industry, and that you know a company is shipping 10,000 tons of raw cotton to the yarn spinner, okay, then the yarn spinner should be able to provide documents that approximately match that amount, and then the yarn spinner should be able to provide documents that approximately match what that quantity is being provided to the next company up in the supply chain, the fabric manufacturer, so on and so forth. But it's a great question, and we absolutely acknowledge, and I think customs does as well, that in many instances you're being asked to prove a negative, and it's very difficult. And so to some extent, you know, either by providing affidavits or by trying to match up quantities along the supply chain, we have found that that's really the only way to do it. Another question. We work with buying agents in China who manage the different suppliers shipping goods to us. Please advise if it's okay to share the slides with them. Absolutely. These slides are for anybody on the webinar, and please feel free to forward them to anybody else in the supply chain. Another question, on what basis determines that this shipment has a connection with Xinjiang? That is a really great question, okay? And I've heard people ask that question directly to the forced labor people at customs, and their answer is something along the lines of, well, we have experts, okay? Well, you know, exactly how are they going to do it? What's the standard that they're going to hold themselves to? They've never really been 100% clear, and we have absolutely seen instances where the evidence that customs might be relying on is something a little bit less than what we would like to see, and particularly if you were ever going to go to court. So the last question that we're going to take briefly, how does this law compare to the revisions to CATSA regarding North Korean labor? The ruling that we provided earlier actually goes to that. clear and convincing. So to some extent, you don't want forced labor in the supply chain in any way, shape, or form. So I think that brings us to the top of the hour. And we thank you all very much. We hope that the webinar has been informative for you. Thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, the program has been approved for legal education hours. And to report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And be sure, please, to complete our short survey. We really value your feedback, and particularly for any future programs that would be applicable to your business needs. So on behalf of Jasmine and Billy and Husch Blackwell, this concludes our seminar, and thank you all very much for attending.